Hello, this is the Civil Liberties and Civil Rights Section A lecture. Our prioritized standard is Government Civics 23. Objectively, we're going to evaluate the balance between First Amendment protections and government restrictions against it. The Supreme Court and the judiciary has an important role in defining and securing civil liberties, which are protections citizens have against government actions. Now, prior to the ratification of the 14th Amendment to the U.S. Constitution, the rights granted in the Bill of Rights applied only against the national government and not against the several state governments. The 14th Amendment's Due Process Clause states that no state can deprive any person of life, liberty, or property without due process of law. Now, because of the Due Process Clause, most but not all of the Bill of Rights protections have been applied against the states. For instance, the court has not incorporated or included the protections against quartering of troops, which is the Third Amendment. They haven't given states the right to a grand jury, which is the Fifth Amendment, or the right to trial by jury in civil cases, which is the Seventh Amendment, into the Due Process Clause, which means we don't know if you have a right to these things at the state level because the Supreme Court has never said that you had a right to these at the state level. Should be pointed out the right to keep and bear arms, the Second Amendment. This was just incorporated in 2010 when they determined that individuals have a right to have a handgun for self-defense. Yet the Supreme Court has never struck down any state gun control law. The very first time court ever heard a challenge was actually 2008, which had to do with the District of Columbia. But generally speaking, the right to own a gun for a citizen is actually a new right. Again, just 2010, so that's less than 10 years old. U.S. citizens are guaranteed many rights, but only as long as these rights do not infringe on the rights of others. Now, the First Amendment prohibits both an establishment of religion, known as the Establishment Clause, and also any interference by government in the free exercise of religion, which is known as the Free Exercise Clause. The Establishment Clause guarantees that church and state are to be separated in the U.S., but that does not mean that church and state cannot coexist. It just means that there has to be very strict limits on it. The government must maintain strict neutrality, neither aiding nor opposing religion. The court has also held that public schools cannot sponsor religious exercises, but they have never actually held that individuals cannot pray when and as they choose. Also, state aid to parochial schools, which means religious schools, is constitutional, yet the purpose and primary effect must be clearly secular. By secular, that means not religious. Now, while the Free Exercise Clause guarantees the freedom of religious choice, it actually does not give a person the right to do anything they want in the name of religion. For instance, you cannot violate criminal laws, you can't offend public morals, you can't otherwise threaten the health, the welfare, or the safety of the community in the name of religion. The free exercise defense is not uniformly accepted. For instance, the Mormon, not anymore, but Mormon committing of polygamy, this is not accepted use of the Free Exercise Clause. Saying that your children can't be vaccinated, that has not been universally accepted. Opposing the military draft due to religious objections, this has not been considered an acceptable use of the Free Exercise Clause. Now, the court has found many government actions incompatible with the free exercise guarantee. For instance, Amish taking their children out of school after the 8th grade. Courts have determined that this is okay. Jehovah's Witnesses refusing to salute to a flag, that's also okay. So, mixed bag when we talk about the Free Exercise Clause based on what the Supreme Court has said. Now, this balancing act between the establishment and the Free Exercise Clauses was challenged in the Engel versus Vitale, or Vitale, 1962 case. The court determined in a 6-1 decision that a voluntary non-denominational prayer to start school days violated the Establishment Clause. Now, being non-denominational or voluntary did not actually make it any less unconstitutional based on this decision. Now, this decision remains a very unpopular decision among a majority of Americans even today. Now, the Engel case was actually the first of several where the court used the Establishment Clause to eliminate religious activities of all sorts that had traditionally been a part of public ceremonies. So things like prayer at football games, prayer during graduation, a lot of these things have gone away due to cases like the Ingle versus Vitale case. In Lemon versus Kurtzman of 1971 case, the court established a three-pronged test in order for a government law to avoid violating the Establishment Clause in an 8-1 decision. Meaning, so what can the government do to aid religion and not actually be a violation of the Establishment Clause? So this gave states more guidance on how they could actually balance the establishment and the free exercise clauses. First off, it must not foster what's considered excessive government entanglements with religion. Second, its primary effect must be one that neither promotes nor inhibits religion. And third, a government action, the law must have a secular or non-religious legislative purpose. So for the government to do something and not violate the Establishment Clause, you have to meet all three of those criteria. Now, the First Amendment guarantees freedom of speech, although this freedom has had challenges to it. Expression of unpopular speech and types of symbolic speech are usually protected as long as they are peaceful, as long as they don't incite any violence, and are not contrary to the constitutional powers of the government. So, like protesting, generally speaking, is usually okay. Now, in Texas, there was a person, his name was Johnson. He's the fellow with the white shirt on. He was arrested for burning a U.S. flag in protest of the Reagan administration, I believe at the 1984 Republican Convention. Now, in Texas versus Johnson of 1989, the court determined in a 5-4 decision that the burning of a U.S. flag was a protected form of expression. The court further held that state officials did not have the authority to designate symbols to be used to communicate only limited sets of messages. So even though a lot of Americans are opposed to the idea of burning a U.S. flag, Supreme Court's actually said this is okay. Commonly, students will suspend some of their freedom of speech upon entering school. Yet in Tinker versus Des Moines of 1969, the court determined that students did not lose all of these speech protections when they entered school. Now, several students decided to wear black armbands to school to protest the Vietnam War, like the one seen here. The school passed a dress code policy banning the armbands, believing that they would cause a disruption to the school day. Now, they didn't actually cause a disruption, but they thought they might cause a disruption, so they banned them before they even wore them. The court determined in a 7-2 decision that students actually retain some freedom of speech and that the school actually had to prove actual interference to the school day to justify censoring of speech. Now, had they worn these to school and fights would have broken out and then they decided they wanted to ban them, that would be perfectly within the realm of what the government is allowed to do. But basically, since they passed it before anything happened, that's what made it a violation. Now, no one actually has a freedom to speech prompting others to commit a crime, like was famously illustrated in the Schneck versus United States 1919 case. So also things like inciting a riot, encouraging the overthrow of the government, obstructing the draft, all these types of things, generally speaking, the government can restrict. The court determined in a 9-0 decision that Schneck encouraging draftees to oppose the draft during World War I was not protected free speech. What they said was, since his words had the potential to create a clear and present danger to public order, Congress had a right to prevent it. In a case with similarities to the Schneck case, Gitlow versus New York of 1925 supported some government limitations on free speech, yet at the same time extended some protections. The court determined in a 7-2 decision that New York State had a right to punish speech that encouraged a socialist revolt of the government through distributed publication, which was called the Left Wing Manifesto. However, the court did extend the First Amendment protection of freedom of speech against state governments. So it wasn't until this 1925 case that you actually do have a freedom of speech at the state level. Other forms of expression are not protected by the Constitution. For instance, no person has a right to libel or slander another person. And by libel, those are written lies about a person, slander are vocal lies about a person. Also, the government can and does prohibit obscenity, which could be either written or spoken obscenity. In Miller versus California of 1973, while the court reiterated in a 5-4 decision that obscene materials did not enjoy First Amendment protections, it actually gave greater context to what was considered obscene to include works that lacks serious literary, artistic, political, or scientific value. So if you don't meet any of those criteria, then they can actually restrict that. The First Amendment guarantees freedom of the press, yet this freedom has been challenged at times. The common challenge to the freedom of press by the government is the threat to national security. For instance, the media is not guaranteed confidentiality of their sources and can at times have their material censored. So this usually happens possibly during a wartime situation where they could possibly censor what you're reporting. In 2012, Edward Snowden, he actually leaked NSA documents to the press, yet the government said it violated national security. Snowden is now a fugitive from the United States, hiding in Russia from our own government so that he can escape prosecution. Now, this defense of national security has not always worked for the government, as highlighted in the New York Times versus United States of 1971, where the court determined in a 6-3 decision that the publication of the Pentagon Papers would not cause an inevitable, direct, and immediate event negatively affecting our national security. Sometimes this is referred to as the Pentagon Papers case. Was actually an opinion and not an official traditional case. Now, the First Amendment also protects the rights of peaceable assembly and petition. That includes a right of association. And by right of association, this is the right to associate with others to promote political, economic, and other social causes, meaning you can form groups with other people, and the government can't stop you from it. Now, the Constitution does not give people the right to incite others to violence, however, to block a public street, to close a school, or otherwise endanger life, property, or public order. For instance, the court has held laws requiring advance notice and permits for demonstrations in public places. Also, people do not have a right to trespass on private property. All right, this concludes Civil Liberties and Civil Rights, Section A lecture discussion. Our prioritized standard was Government Civics 23, and objectively now you can evaluate the balance between the First Amendment protections and government restrictions against it.